And to condemn every man in this country as a rapist is not advisable in this august house.
भारतीय संदर्भ में पति पत्नी के रिश्तों में और विदेश में इन संबंधों में जमीन और आसमान का फर्क है.
It's March 2022, a month that has been globally celebrated as Women's History Month for years. It's a month when we celebrate Women's Day with a lot of fervor, promises and hope. But all of this falls short when we look at a gory reality where it is perfectly legal for a man to rape a woman as long as they are married. India is one of the 32 countries where marital rape is still not criminalized. But why is that so? What does the law say and what are the loopholes? In this video, we explain why marital rape is still not a criminal offense in India and why is that a problem. What is marital rape? In legal terms, marital rape refers to the act of non-consensual sexual activity perpetrated by a husband on his wife, which has been obtained by force or under the threat of violence. The lack of consent here is the key element. Historically, sexual intercourse within marriage was regarded as a right of spouses. The idea stems from the problematic belief that a wife was a husband's property. The earliest laws defined rape as a theft of a man's property and did not consider it a crime against women, and hence the same laws also dictated that rape was not possible within marriage because a man could do anything with his property. What does the law say about marital rape? While as a society we have progressed and have left behind several ideas of the earlier decades and centuries, the notion behind considering women as a man's property and laws around marital rape continue to be archaic. Over the years, even though rape laws evolved to view rape as a crime against women, it wasn't looked at as an offense within the institution of marriage. In the 18th and 19th centuries, the stress on women's chastity and purity increased. Rape was seen as something that women faced outside their houses. It was with the influences of these laws and notions that the Indian Penal Code was drafted in 1860. The definition of rape, according to the section 375 of Indian Penal Code, specifically excludes marital rape unless the woman is a minor. While various movements have led to changes in India's rape laws, the exception of marital rape, however, still stands. Let's have a look at the numbers. The patriarchal society that we live in has time and again tried to falsify and hush narratives and incidents of marital rape. But numbers cannot be silenced. According to the NFHS 5 survey, more than 30% of women in 5 out of 22 states and union territories in India said they have suffered spousal violence in the form of physical, emotional, sexual abuse. Furthermore, a 2021 report by the WHO has revealed that over a quarter of women aged 15 to 49 years who have been in a relationship have been subjected to physical or sexual violence by their intimate partner at least once in their lifetime. While an older study by the UN Population Fund has revealed that 75% of married women in India were subjected to marital rape. These numbers have only compounded as a result of COVID-19 pandemic and the subsequent lockdowns. We must also take note of the fact that marital rape remains heavily underreported. It is estimated that less than 1% of marital rapes are reported to the police, while according to data by the Harvard Law Review, 1 in 3 men in developing countries like India admitted to raping their wives. So why is there an exception for marital rape? The reason behind the shocking data is not just limited to statistics or law. There is a much larger cultural and social stigma attached to it. The deeply misogynist and patriarchal society views the institution of marriage as a right of husbands over their wives' bodies. The larger belief still exists that sexual violence happens outside the home. The concept of rape within the home in a marriage is considered to be a private matter, and hence there is no protocol or recognition for the same. The concept of consent does not exist in this ambit, and the fact that a woman can refuse sex within marriage is not accepted. The irony and the absurdity of the law is such that while murdering one's spouse is criminal and is considered a violation of their right to equality, rape within marriage is still not a criminal offense. So what are the loopholes in the law and what is the ongoing debate? The Delhi High Court is currently in the process of hearing final arguments in a series of public interest litigations challenging the marital rape exception clause in Section 375. The arguments both within and outside the court have been debated widely. The fact that the case is being heard in court has sparked social media debates about men's rights and the impact of false allegations on the sanctity of marriage in the Indian society. Some people even started a marriage strike campaign, refusing to get married as a result of the deliberations being made in court. There has been a massive push to save the family system by protesting the effort to criminalize marital rape. While there have been one-off instances of high courts speaking out openly against marital rape, considering it grounds for divorce and abortion, it has still not been labelled a punishable offence. Violence against women is a major public health issue and a violation of women's human rights. Rape is rape, and marriage could not be a ground for an exception. Marriage does not mean sexual subjugation of women as much as rituals, celebrations, and pop culture might have us believe. 52 countries around the world have outlawed marital rape. The fight to do the same in India is not just about changing laws on paper, it is about attacking the belief system that considers marital rape okay. The fight is against the larger culture that denies women their rights, autonomy, agency, and respect.